All right. Good afternoon, everyone, and welcome to our December in the Boardroom on County Board Rules Part 2. This is our final in the boardroom for 2023, and we want to thank you for joining us for the last, I think, 11 months. I believe February was our first in the boardroom. So we appreciate your participation and hope to see you back for our 2024 series. We have a lot of information to get through today for our in the boardroom. So before I turn it over to Andy and Jake, I'm just going to give a couple of quick reminders. First of all, I want to remind everybody that if you have a question during the webinar, please use either the chat or the raise hand feature, and we will get to the questions as soon as we can. We do have a number of slides that we're going to go through today, so we may not be able to take everybody's questions as we go along, but we will get to the questions at the end if we don't get to them during the presentation. In addition, this webinar and the slides for the webinar will be recorded and placed on the WCA website. So if you'd like to look back either at the webinar or at the slides, those will be available for you later on this week. So with that, I think I'm going to turn it over to Andy and Jake at this time so we can begin the webinar. And again, thank you for your patience as we had a little bit of a technical difficulty there earlier.
Awesome. Thanks, Sarah. And good afternoon again, everybody. I'm Andy Phillips, along with my partner, Jake Curtis. We're here with Attolles Law. And so in today's discussion, this is the follow-up from last week. And last week, we introduced concepts surrounding board rules and covered the first two very big umbrella topics that we think ought to be addressed in board rules. And today, we're really going to dive into some detail about the procedural issues that confront the county board and the county board committees in terms of meeting process and procedure. I want to stress this again. I stressed it last week, is that there is no right or wrong way to address board rules, that every county is going to do things a little bit differently, and that's just fine. That's okay. The important point is let's set some procedural rules that are going to avoid disputes going forward on matters that make their way through the board and through the committee structure. The more we can avoid those sorts of disputes, the more efficient we are going to be at getting at the actual business before the county board, which is the important part of county government. And so again, what do we want to accomplish today? We just want to recognize the different procedural issues that may exist and that we can and should address within our board rules. Again, not one size fits all. You're not going to see template board rules here. There is no statutory prescription on what board rules have to look like. But in your county, in your situation, what do you need to address? Let's break all of these procedural issues into digestible topics, because if we just start making a laundry list of all the procedural issues, it's going to be a very long list. And so how do we break those issues into digestible topics? So again, we have coherent board rules. And then just let's think about how business is currently transacted in our county and how can we improve upon that business. So without further ado, let's talk about procedural rules. I want to start with this slide because I started with this slide last time too, is that we have to understand the order of precedence as it relates to board rules. Where do board rules fit in the hierarchy of rules governing our process? We have state statute, and state statute trumps county ordinance trumps board rule, but board rules trump Robert's Rules of Order. What do I mean by that? We can't have a board rule that is inconsistent with Wisconsin's open meetings law. The open meetings law is going to apply. We can't have a board rule that is inconsistent with an existing county ordinance. That existing county ordinance is going to apply. But board rules can supplant Robert's Rules of Order. In fact, Robert's Rules of Order specifically recognize how we could have a board rule that trumps Robert's Rules of Order. So, and this is just an example, if we want to make it that calling the question or moving the previous question is not a 2/3 vote, it's a majority vote, we can do that within our board rules. I would advise against that, but we can do that in board rule if that's what we want to do. And so when we think about the concept of procedural rules and what they do, it defines how business is transacted within a board or committee meeting, and it can also relate to how business gets before a board or a committee. And so again, these procedural rules are very important to avoid disputes and disagreements about how we operate as county government. I mentioned last week that Jake Curtis has the privilege of not only being a lawyer that represents county governments throughout the state, but he's also sat in your chair as a board member. He is a former Ozark County Board Supervisor. And so I think Jake will tell you that procedural rules are critical in helping get business through the county board. Anything you wanted to add on that, Jake?
The only thing I would add is I would really emphasize your point about avoiding disputes. You know, we occasionally will have to help county boards navigate kind of midterm disputes about the rules, and that's just it's never a good discussion. It's never helpful, and as you alluded to, Andy, it really does distract from the business of county government. So, you know, these are obviously foundational rules. And so if there's a midterm, you know, significant dispute relating to a rule, I mean, it's understandable that really the at least procedurally, the business of county government, at least from a board standpoint, really comes to a halt. Because obviously it's like if you don't have your rules, you can't continue to operate. You can't change the rules, you know, halfway through a game, so to speak. So it is really important that, and it's great to see so many people on this call, because now is a great time as you're maybe entering, you know, come spring, a new board, to have those rules in place and then have that healthy discussion on the front end. Because again, I'm not suggesting it's wrong to change them or make revisions, but to make substantive changes midterm, we have seen cause some real conflict on the board.
So when I talk about breaking it down into digestible headings or topics, this is what we're talking about. And these are just examples that you can use, and we are going to actually use these topics to guide our discussion today. We'll go through each of these, but this again is not a template. If you have different topics that you want to address within your board rules, by all means, use those topics. So what we're going to talk about today is the scheduling of meetings, the form of resolutions, resolution referral process, agendas for committee meetings, resolutions and county board action, seating arrangements, agendas for county board meetings, the order of business for county board meetings, conduct at meetings and rules of decorum, remote attendance at meetings, the voting process, the definition of session, parliamentary procedure, and interpretation of the rules, board rules, and Robert's Rules of Order. So when we talk about scheduling of meetings, you're going to see a lot of bullet points within this discussion today that are ending with a question mark. That's because it's not for us to tell you how things ought to be done, but it's for you to consider the question, answer, first of all, does it need to be addressed? Number two, if the answer to does it need to be addressed is yes, how do we best address it? So here we go. Specify regular meeting dates and times. How can those meeting dates and times be modified? Is it by the chair? Is it by the chair after conference with a particular committee? Is it by a majority of supervisors? How is it that we change meeting dates and times? How can special meetings be scheduled? I know that there's a provision in 59.11 of the statutes that allows a majority of the supervisors to petition for a special meeting, but should we also have a provision within our board rules that allows a certain number of members to call special meetings? And if so, under what circumstances? Are we going to have special meetings such as around budget time, where we know that there is going to be a need to get together, whether it be the full county board or committee of the whole, where we need to get together and really get information shared in a meeting format, but it's not going to be your typical meeting of the county board. If we have a regular calendar every year associated with those special circumstances, then let's put in our board rules what that looks like. How are public hearings scheduled? Who's responsible for ensuring appropriate notice is published, and so on. And so again, these are all topics that you need to address as it relates to the meeting schedule.
Andy, I would if we go back to the previous slide, that last bullet in my mind is really an important one. You know, we see situations where, you know, there's a very hot topic in a community, in a county, and there's a desire on the part of you know, maybe majority or even just a few select supervisors that are hearing kind of an outcry from the public, so to speak, and there's really no mechanism, if the board rules don't recognize that, for just a public hearing, right? The point is, town hall, public hearing, whatever you want to call it. But I think it is very helpful to have some framework as to what that looks like, as opposed to just kind of being quiet on that topic and leaving it up to the chair to kind of decide, well, what happens when you have, our firm's been involved in some of these solar issues, which, there's a lot of pros and cons, right? People get very passionate about that and nothing wrong with it. But, when you have a topic like that, that's going to generate a lot of discussion, a lot of debate, as opposed to trying to, maybe jam in, we've seen extended public comment on an agenda where the board still has lots of other work to get to and a lot of action to take. It can be difficult if then there's 3 hours of, public comment. In that scenario, it makes sense to have something in the board rules recognizing that there's a process for the members of the board, or maybe the chairman in his or her own ability, to set a public hearing, a town hall, whatever you want to call it, so that, we can just set 2 hours where the board's going to be there. They're going to be listening. They're not debating the public. They're not taking any action. They're there to listen. And it's just an opportunity for the public to express their views on a certain topic. I just think sometimes we forget how important that can be. And if it's not addressed in board rules, then it puts the chair in an uncomfortable situation to basically make it up. And usually they can still figure out a way to do it, but it's much better if you're relying on a board rule.
Totally agree, Jake. So we had a good question from Jody, and this isn't addressed in today's discussion, so I want to address it now. She has a question about suspension of the rules. If you have a provision in the board rule calling for a particular procedure related to suspension of the board rules, then lay that out in the board rules. You have to follow that process, whatever is in the board rules, if you address this question of suspension of the board rules. In the absence of addressing this in the board rules, suspension of the rules requires a 2/3 vote. And so you can only suspend the rules by 2/3 vote. I will tell you that if suspension of a particular rule is consistently being requested, we need to revisit that rule, because suspension should be the extreme outlier. It should not happen very often at all. All right, form of resolutions. We know in 5902 of the statutes how county boards exercise their powers. And we know that we cannot modify section 5902 as it relates to the exercise of those powers. But our board rules can inform the particulars as to how those powers are exercised. We know that official action is reflected in an ordinance or resolution, but how is it that our ordinances or resolutions are described or captioned? Do we have a particular form for the title of a resolution or an ordinance? Should we have that type of form? Does a committee need to sign off on a resolution that gets forwarded to the county board? If we have a committee sign off, do we have a signature line for everybody that was on the committee, just those who voted in favor of the particular resolution? Or what happens if somebody refuses to sign? What happens to that resolution? Does it get forwarded to the county board nonetheless? We're going to get into that in a little bit as it relates to the committee involvement in the process, but these are all questions that can be addressed within your board rules. If you want to see information, whether it be resolution or even a report from either a committee chair, department head, county administrator, whatever the case may be, if the county board expects that to be in a particular form, let's put the form right in our board rules and specify exactly how we want to see that information. Along those lines, what is the introduction process as it relates to the resolutions? Do we submit them to the county clerk, the board chair, both? Do we submit them to a particular committee? Is there a deadline for submission of those resolutions? Do we allow for co-sponsors in the legislature? If you take a look at every assembly bill or Senate bill that's introduced, it's going to say introduced by and co-sponsored by. Do we have that same process in our county? When we have ordinance amendments, if we have a request to modify an existing ordinance, do we have one person designated to draft those amendments? I think the answer to that should be yes, and I think that it ought to be corporation counsel. I don't think that we should leave individual board members drafting ordinance amendments because of the legal implications. And so I think all of those amendments go through corporation counsel. Do we have one person designated to draft budget amendments, whether it be the administrator, finance director, controller, and so on? This is an important point, fiscal notes. Remember I said before that if we want certain information in a certain format, let's put it in our board rules and make sure everybody understands the expectation as to the form and format. Fiscal notes are a very important concept here. I can't tell you how many times I've been in county board meetings where we have a resolution introduced. It's directing the county to take action in a certain manner. And one of the first questions asked is always, how much is this going to cost us? What is the impact on our budget? Should we have a place on our resolutions where the fiscal note is attached so that the finance department weighs in on what the anticipated cost of a particular resolution is going to be? For that matter, if we look at the end, we've got legal notes here. Should we have the corporation counsel weigh in on these resolutions as it relates to the legal authority of the county to do what the resolution is requesting the county to do? So again, you don't have to have any of these things for a resolution. The law doesn't require this. But if you have an expectation that this information is going to be contained within a resolution or an ordinance as it's introduced to the county board, let's make sure we specify that in our board rules.
I would put in a plug there, Andy, for, I mean, and I think you would agree, we certainly see a lot of issues, not to suggest that we need to add to the workload of corp counsels, but I think, you know, to the extent there are corp counsels on this call, I think many of them probably would agree. I'm assuming they would rather have a shot at reviewing language on the front end as opposed to having something proposed to the county board and either getting asked, you know, on the spot whether or not there's any sort of legal issues, or even, you know, worse, having something pass and then have there be questions after the fact. And so, and, you know, Andy, you and I have dealt with issues where, you know, there's questions with respect to how something is drafted and somehow it gets passed and then corp counsel gets asked after the fact, right? That's not a good position to put your corp counsel in, and then frankly puts the board in a bad spot if they need to, you know, revisit something that may be passed that included, you know, illegal or incorrect language. So I would think it, you know, maybe it's not necessarily a board rule, although I'm not sure it would be bad to have that, but maybe a best practice to certainly have your corp counsel have some sort of role to review beforehand, to have put them in a position where they can identify any problematic language and again address that before it's on the board floor, or worst case scenario it's passed.
No, I totally agree. I think it's somewhat unrealistic to ask corporation counsel to pass on each and every resolution because frankly, corporation counsel has a very important job and a series of duties throughout the county. So it's difficult to find the time to go through each and every resolution, but having some sort of process in place to make sure that any outstanding legal questions are addressed is critically important. Totally agree. The referral process. What happens when a resolution or an ordinance amendment is introduced? Does it have to go to a committee before going to county board? And if the answer to that is no, how does a resolution get before the county board? Is it a matter of a member of the board submitting the resolution, the proposed resolution, to the county board chair, to the county clerk? How does it get on the agenda? We see a lot of counties who have an automatic referral process where the resolutions go to the board chair and the board chair refers out to committee even before a meeting occurs. You can do that. If you're going to do that, have that process laid out in your board rules. Authorize the chair or a committee to refer all of these resolutions to the appropriate committee, boards, and commissions. It again asks the question, is that referral going to take place outside of the board meeting? And what happens if the county board disagrees with a particular referral? Can the county board override the board chair's referral? Again, the law doesn't specify yes or no on that. It's up to your county board to decide how that referral process is going to work. But it's really important that we address this in the board rules because there is this concept that resolutions can go to die in committee. And even if you don't have a process where they can die, they could, where a committee chair just refuses to place an item on an agenda and it just sits and sits and sits. And so having a process in place to address this helps inform everybody about how this referral process works. This is another important point too, is that oftentimes we see resolutions being advanced by one particular board member or group of board members because it's an important issue to their constituents. When it gets referred to committee, are we going to allow the sponsor, the person that this resolution is really important to and their constituents, are we going to allow that person to speak first at either the board meeting or the committee meeting? Let's specify in our board rules that that may be the case if we believe that to be important. Before we move on to committee agendas, Jake, anything else you want to add on resolutions, giving your experience and insight?
No, I mean, you know, you had mentioned my experience as a supervisor. I mean, I think I did find it frustrating. You know, had mentioned in the previous slide kind of the role of maybe a sponsor. I mean, I think from a supervisor's standpoint, particularly in Ozaukee County, again, I'm always a champion of Ozaukee's committee model with 5 committees, but I look at some of these counties that have 20, 25, 30 committees. You know, I think it would be frustrating from a supervisor's standpoint to be able to track resolutions that have, or ordinances that haven't yet gotten to the full county board for consideration. And so I think that's just simply a point to make, that having these board rules in place, that there is clarity on what happens, can help. Because I guess my point is that in some of these counties with a significant number of committees, it can already be maybe a daunting task and a little bit overwhelming from the perspective of the supervisor that's not involved in the debate relating to that ordinance or resolution. And so at least if you have clear rules as to kind of how, you know, how that gets forwarded to the board, if there's an amendment, where does that go? What's the role of the sponsor? I mean, I think those are all important to have laid out on the board rules, so that there's some certainty from the supervisor's standpoint that may not be involved, but still wants to track it.
So I think when we're talking about the particular form of resolution, we also want to create some regularity as it pertains to our committee proceedings. And so we ought to have an agenda format for our committee meetings. Again, if we want a regularity, then let's specify in our board rules what that regularity looks like. Date, time, place, matters to be discussed, the content of an agenda. Let's have a form for that. Our resolutions ought to have a number and a title. And so we ought to use the nomenclature that we want to see and put that in our board rules. Does the chair of a committee have the discretion to place items on the agenda that have been referred from the county board, or is it automatic, specified in our board rules? Can members require an item to be placed on the agenda? Committee members, let's specify that in our board rules.
I would echo that point, Andy. You know, I think it's fair to say that we see friction on the point relating to whether or not other members of a committee, or, you know, this can be applied to the full board as well, but do other members of the committee have a role or have an ability to get something placed on the agenda? It may seem like a you know, a trivial point, but we see a lot of friction there, where for whatever reason, a committee chair or the board chair may not want something on the agenda. But I think it is important to have some kind of pressure valve, so to speak, so that if you have a buildup of supervisors that want something placed on a committee agenda or a board agenda, that there's at least some path forward. And I don't know if that's a majority or a super majority, right? I think that's up to you as a board to decide. But I think there can be problems if you have kind of more that old school approach of the committee chairs, the board chairs completely control the agenda, and, you know, they're the final say with respect to placement on agenda. I mean, I'm not saying it's right or wrong, but the reality is, if you don't have some mechanism to have a majority of supervisors get something on an agenda, and a chair for whatever reason doesn't want that placed, I think that can cause real friction and put, you know, frankly, your department heads, corp counsel, in a somewhat awkward position.
In the same way that we want to address how special county board meetings are called outside of the 59.11 process, how are special meetings of a committee called? Let's address that in our board rules. Can the primary sponsor of a resolution request that we delay consideration of that particular resolution? Nancy brings up a good point that I want to talk about very briefly. And she had suggested that if we have a co-sponsorship process, that we might have walking quorum issues. That's entirely accurate. So if we have, and a walking quorum by definition is a gathering or series of gatherings where individuals commit to a particular course of action on behalf of the governmental entity. And so really, and again, I'll tell you my old line, which is, somebody tell me the substantive difference between the definition of a walking quorum and the definition of politics. There is no, in my mind, substantive difference. That said, the law says that walking quorums are illegal. And so if we have a co-sponsorship process on a resolution, there is the possibility that we get a sufficient number of people to direct the outcome of that particular resolution before it's ever introduced on the board floor. We want to avoid that, okay? So again, if we have a co-sponsorship process, let's avoid any sort of hint at a walking quorum, which is why you may want to say we don't want a co-sponsorship process in our county, and that's just fine. Again, the importance being have a discussion with corporation counsel about how this is going to work in reality. County board action on resolutions. What is the process for getting resolutions and ordinance amendments on the agenda when the committees have acted? Do the committees forward that to the county clerk or the board chair by a date certain so that it can get published with the agenda out to the county board? When I say published, I'm not saying published in a newspaper. I'm saying distributed out to the county board. And so let's have a process where committees act on something and then it comes back to the county board. When it comes to actual county board action, Robert's Rules recognizes that we don't have to have somebody move and second adoption of the resolution if the committee itself is recommending adoption of the resolution. In other words, let's say we have a committee of 5, and in our board rules, we say that the committee, when they recommend approval to the county board, at least 3 members of the committee have to sign. We know that a majority of the committee then supports the particular resolution. Robert's Rule says that the committee recommendation itself acts as a motion and second. So there is no need for a motion and a second when we get it to the board floor. It's already up for debate. All right. So consider codifying that within your board rules as well. The next point is a point that I'm going to address when we get to the definition of session later on in this discussion today. But what happens to pending resolutions, ordinances, or ordinance amendments when we end our session? All right. And I'll get to the definition of session later, but let's for a moment consider what happens to pending resolutions, ordinances, and ordinance amendments that are sitting as of April 10 in an even numbered year. The election happens first week of April. The organizational meeting happens third Tuesday in April. So do we start with that organizational meeting with a series of business items that have been pending from the prior board, or do we wipe the slate clean? There's no clear definition on that, which is why I will tell you later that it's critically important that we define what session means, because in Robert's Rules, the term session has a particular meaning and it triggers all sorts of different rules within Robert's Rules. But let's define within our board rules what happens to these items that are pending, whether they carry on. Understand that the county board can discharge a committee that fails to act. And when we think about this, and why is it that a county board can discharge a committee, disband a committee? Well, it's because the committee is subordinate to the board. The committee is a subset of the board, and a subsidiary entity can never act independent of the parent body. And so in this instance, the parent body is the county board, and the county board ultimately retains the authority to direct the committee what to do, and a committee that fails to follow that directive can be discharged. Again, if we're on the board floor, we have a resolution pending, we have an ordinance amendment pending, we have a member of the board that wants to amend what has been introduced, consider whether we have a rule that any such amendment be in writing. I'm not saying that that's what you have to do, because I know there are many counties out there that don't do that. But the reason that you may want to consider this is so that the chair, the clerk, and all of the other members of the county board understand exactly what is being accomplished with the proposed amendment. We have a question here. The statutes require the maker and second of a motion be recorded in the minutes. How do we comply with that statute if no formal motion is needed? Great question. That's an awesome question. Yes, if it is a simple motion, the statutes require that we put that in there. If we have a committee recommendation on a resolution that Robert's Rules recognizes we don't need a motion and a second from an individual member, our minutes reflect that the committee is recommending adoption of the proposed resolution. Seating arrangements. Sounds silly, but oftentimes there's dispute about where people are going to sit within the board room. So what is our process for determining supervisor seat selection? I know many counties have a custom or a practice of ordering the seats in numeric order according to district number, front to back. Is that what we want to see? And then what happens when we have somebody in District 27 who wants to sit at the front? Are we going to allow that? The supervisor from District 27 says, I'm a little bit hard of hearing and I'd rather sit up front so I can make sure I can hear everything that's going on. Chair allows it. All of a sudden, we've got a controversy because an individual from District 8, who is then bumped to the back to accommodate District 27, said, I don't like sitting in back. I much prefer sitting in front because my eyesight isn't as great as it once was. So I want to be there to be able to see things. Then we have chaos because it creates all sorts of problems. If our board rules address supervisor seating and whatever the process is to request movement of supervisor seating, we don't have that big controversy. We have to designate places for the public, press, staff, court counsel, county clerk, administrator, department heads of public to address the board. In other words, we ought to have some sort of regularity to the seating arrangement and the way that the meeting is going to be conducted. County board agendas. This is a topic that I think gets asked of us, Jake, quite a bit. How do I get an item on the agenda for the county board meeting? I know in the absence of a board rule that you look at Robert's rules and the board itself controls the agenda. And so you always have the ability as a board member to make a motion at a meeting that an item be placed on the agenda for the next meeting. If that motion is seconded and it's passed, adopted, then the board chair doesn't have discretion. The board chair has to put that issue on the agenda. Short of that motion process, do we have some sort of process for getting items on the agenda? Is it solely board chair discretion? Is it through a committee? Let's define what that process is within our board rules. Should all items acted on by a committee automatically be placed on the agenda? Kind of gets back to a previous discussion about what happens with resolutions or proposed ordinance amendments after they get through the committee process. What is the deadline for getting those items back to the county board chair and clerk to make sure that they're on the agenda for the next county board meetings? Do all items have to go to a committee first? Is there a process where a supervisor could request that we bypass the committee process and get it immediately to the board floor? If that's something we want to see, we put that within our board rules. What's the deadline for submission of these materials to the board chair or clerk? Should all items be in a resolution format? My answer to that is yes, they should be. And then we should specify what that format looks like. We had a quick question from Terry here. Would ADA accommodations apply to board members? Great question, because we have both Title I and Title II of the ADA that are applicable here. We have Title I accommodation for the public, Title II employment. And so the question is whether we have an obligation under Title I to accommodate under the ADA for board members. The answer is probably, but I'm not going to say specifically absolutely, because that is somewhat of an open question. We dealt with that question in the context with a different client a couple of years ago, and there's not exactly clear guidance on exactly what types of accommodations are going to be required. But I will tell you that you're in a much better legal position in accommodating than you would be without accommodation. So our recommendation would be to accommodate. Order of business. I put in there in big bold letter sample because there is no prescribed order of business to a county board meeting. This is merely a suggestion. If you look at Robert's Rules of Order, they're going to have an order of business that's different than this. Robert's Rules of Order also recognizes that you don't have to follow that particular order of business if you want to deviate. I would suggest to you that if we have a particular order of business that we want to follow to establish regularity, meeting to meeting to meeting to meeting of the county board, let's put within our board rules what the typical order of business is going to look like. And you'll see in this order of business that we hit all of the things that we think are important to address at a county board meeting. And you may be looking at this slide saying, well, they obviously missed X, Y, and Z. That may be. Things may be a little different in your county, and that's okay. We didn't intentionally exclude X, Y, and Z. We just put on here what we typically see in county board meetings. So if X, Y, and Z are important to you, let's put X, Y, and Z on this list. But you'll see here that there is a particular cadence to what we've listed out. We've got call to order, roll call, pledge of allegiance, special matters and announcements, approval of the previous meeting's minutes, consent calendar, so we can take all of the items that are routine, put them under one agenda item so that we can adopt all of them with one singular motion. Any unfinished business motions that are carried over from the previous meeting, ordinances and ordinance amendments, award of contract, resolutions, any special order of business that might be a closed session that may be required for a particular issue, and then we go to adjournment. Again, you may say, well, public comment isn't in here. public comment isn't required by state statute. And so if you have public comment, put it on and if you're going to continue having public comment at your meetings, put public comment on your typical order of business.
So Andy, I'll I'm just seeing if, I don't want to jump ahead here, but I guess I'll pose my comment in the form of a question. So you have your agenda, it's noticed, and you have several action items, and then day before the meeting, for whatever reason, one of those action items become really, really significant with lots of public concern, a lot of public attention, and you have 5 action items. The first 4 are going to take a lot of time, and action item number 5, though, that's the one that has a lot of attention from the public, and you're going to have a boardroom full of members of the county, from the press, etc. I've always taken the position, but I think it's a good discussion point. If the chair says, look, everybody here is here, they're not here to listen to our IT director talk about some IT issue, which is action item number 3. They're here to hear what this board has to say about action item number 5. I've always taken the position that the chair can use his or her discretion to, with the consent of the board, to move that action item number 5 up to action item number 1, because he knows that's really what the public is there for. I guess any words of wisdom on that, because I see this come up frequently.
Yeah, and you'll see oftentimes, Jake, an agenda item that says approve agenda. You don't have to approve an agenda, but sometimes that's a good placeholder on your typical order of business to address exactly what you're talking about. So if we get to an item on the agenda, say it's after roll call, approve agenda, you can say, with the body's permission, I'm moving item 5 up to number 3 so that we can address that with public comment. Any objection? If there's an objection, you've got to take that up and have a motion, a second, and a vote on changing the order of the agenda. Likewise, if somebody makes a motion to modify the agenda, that motion is in order. And if it carries, then the board chair has no discretion. The agenda has to be reordered consistent with what the body says the agenda ought to look like. As a matter of expedience, I would very much prefer that the board chair move things by unanimous consent. In other words, asking if there's objection, and if there is none, the matter gets moved, to your point. We had a couple of questions here, like Fred said, how can we have a motion to place an item on the next meeting agenda if the current meeting doesn't have that on the agenda? Isn't that an open meetings law violation? It's not an open meetings law violation to have something placed on the agenda for the next meeting. As soon as somebody makes the motion to have that issue placed on the next meeting's agenda and another member starts debating the merits of what's going to be on the agenda next meeting, then you have an open meetings law issue. But simply having something placed on the agenda for the next meeting is not going to trigger open meetings law concerns. Dave had a couple of questions about this whole definition of session, which we're going to get into a bit later, so I'll address those in a little bit. All right, conduct at county board meetings. What are our expectations of board members, visitors, staff, and others? And expectations is an intentional word here. I'm using that intentionally with purpose. How do we expect others to behave, and have we given them notice of our expectations? Let's put that in our board rules. For example, no conversation on the board floor or in the visitors section while the meeting's in session. All electronic devices are kept in silent mode, and as it relates to the board, shall not be used during the meeting. I think corporation counsel would echo this, because we don't want public records created during a meeting. We use our iPads that are issued by the county only in accordance with county policy. Designate who has the ability to distribute literature out to the board members. Let's not have the general public just handing out leaflets during a board meeting or prior to a board meeting, that there's a process to distribute literature to board members. Let's distinguish between public comment and public participation. Last week, we talked about public comment, and we talked about the rules surrounding public comment. Remember that the law does not allow for public participation at meetings. The public has a right to observe and record meetings. They have no right to participate in meetings. In my view, and again, this isn't a legal issue per se, it may lead to legal issues, but it's not addressed in statute. In my view, the public ought not participate in meetings. In other words, there should never be a circumstance where a supervisor cedes the floor to a member of the public to address a particular matter before the board. If the public, a member of the public, has information that would be helpful to the board's deliberation on a particular topic, the chair can grant that member of the public the ability to speak to the issue and provide the information. But it is never, in my estimation, in order for a board member to cede their time on the board floor to a member of the general public. Thoughts on that, Jake?
Well, I would have a lot of thoughts on that, but I know we have time constraint here. I mean, I guess I would just say I would agree. I don't think it would be good practice to allow supervisors to kind of, as a matter of practice, cede time to members of the public. That being said, I have, and I obviously won't note what it was, but I've been involved in some pretty contentious meetings where I thought the chair did a very good job of taking a temperature of the room, so to speak, and at various points allowing members of the public to definitely participate, right? We were well beyond comment. This was really board members debating an issue and then members of the public being recognized to kind of interject or make statements. And while normally we wouldn't advise that, I have seen a chair very effectively use his authority to recognize members of the public. And again, if you would have told me that prior to the meeting, I probably would have squirmed and said, let's not allow that. Let's not go down that path, right? They're going to have public comment. But again, just being in that meeting, getting the temperature of the room, it was one of those where I think the chair used his discretion very wisely. And I think a lot of members of the public that had a lot to say, and frankly, some of them were very knowledgeable on the subject. I think the chair knew that allowing them to have some time to address the topic helped from, not only a kind of a PR standpoint of kind of letting them have their time, so to speak, but frankly, I think provided information that the board ultimately found useful. So I think my point would be, like, we're talking about rules, and it's important to have those rules, but that also gets to having a chair understand how to run the meeting, and frankly, a little more art than science in some of these situations.
Cindy asked a good question here. What about department head? Are they members of the public, and should we allow them to explain resolutions? Department heads are staff, and staff, one of their roles is to provide information to the board so the board can make an informed policy decision. And so when a particular resolution comes up, it would be entirely appropriate for staff to address the particulars within a resolution, but that ought to happen through the chair and the chair's recognition of the department head or staff explaining a particular point. Oftentimes, I would say most times, we know that there will be an issue that staff ought to address. The chair should recognize that, and when the resolution is introduced and placed before the board for debate, the first person to speak, if it's not the particular committee chair that sponsored the resolution, ought to be the department head to explain the purpose of a resolution. That's entirely appropriate. Remote attendance. Remember that Robert's rule says that you don't have the right to attend a meeting by remote means, virtually, unless that right is established in your bylaws. And when Roberts uses the word bylaws, I always think of board rules. They mean the same thing. And so again, you have to establish, if you're going to allow remote attendance at your board meetings or committee meetings, you have to establish within your board rules that that is going to be allowed. And then as soon as you allow it, let's define boundaries. In other words, if somebody attends by remote means, does that mean they're counted for quorum? They get to vote, they get to participate in debate. In other words, they have all of the attributes of official attendance at the meeting, or are we going to limit that? And if we are going to allow this, what are the procedures associated with their attendance? If they're going to participate in closed session, are we going to require certification that they're alone when they're attending remotely? What are other rules that we want to place around this entire process of attending a committee meeting or a board meeting by remote means? Let's address that within our board rules. Voting. Understand that any supervisor has the ability to request a roll call vote as long as it's before the next item of business. That's practically speaking irrelevant in many, many counties. In fact, most counties, because we use electronic voting, so it's all roll call vote. We need to record the vote in the minutes. And then there should be if we don't use electronic voting, there ought to be some sort of rotation established so we don't follow the same order as it relates to voting. So we always have Supervisor X preceding Supervisor Y. Let's mix that up a little bit. Understand that there are many, many routine matters that can be undertaken through unanimous consent. That means without objection. And so again, getting back to that whole concept of a consent agenda that I addressed when we talked about order of business, if the board chair says any objection to doing it this way, hearing none, we're going to do it this way. And so again, that's an efficient way of getting through routine items of business. Here we get into a very important concept, and I wanted to make sure we had time for this concept today. That's the definition of session. If we look at Robert's Rules of Order, Chapter 8, Section 2, Sub 2, a session of an assembly, and an assembly in this instance means a county board, unless otherwise defined by the bylaws or governing rules of a particular organization or body, that means within the board rules, is a meeting or a series of connected meetings devoted to a single order of business, program, agenda, or announced purpose, in which, when there is more than one meeting, each succeeding meeting is scheduled with a view to continuing business at the point where it was left off at the previous meeting. We often get this question about when it is appropriate to reconsider a particular resolution that was adopted at a previous meeting, when it may be appropriate to rescind or amend a previous resolution, when it may be appropriate to consider a resolution already considered such that it cannot be brought back to the body again. And all of those things are dependent upon the definition of session. In my mind, I think of a session as being the time period between the elections. So we have third Tuesday of each April where county board members, new county board members take their seats, all county board members take their seats until 2 years later when we have another election. That's what I think of in my mind as session. I know different counties define it different ways, though. Some may define it as a year. Some may define it as the period between the organizational meeting and the annual meeting. And so it really depends on what you want that session to be defined as, but address this in the board rules, because again, the definition of session is going to drive a lot of the analysis of the procedural rules relating to when certain motions or items of business can be brought back before the county board. So define session. That's critically important. I also know that there's a practice out there in some counties where they adjourn, and I'm going to butcher the pronunciation, sine die. It's S-I-N-E space D-I-E. That means to dissolve the assembly. That essentially puts a definite stopping point on all business that has transpired before that particular adjournment, meaning that at the next meeting, everything starts fresh. You don't have to do that, and there may be reasons you do not want to do that, particularly relating to anything that might carry over to the next meeting. But understand that that also impacts the definition of session, because if you're going to adjourn sine die, that means that you are ending that session. Done, full stop, no question. If you intend to do that, fine. If that's not your intent, let's define session differently. Parliamentary procedure. You want to identify the rules that are specific to your county and list common or basic rules of order. In other words, the rules of procedure which are contained within your board rules. And then you also want to designate Robert's Rules of Order, newly revised, latest version, as being applicable in the event a particular question is not addressed within your board rules. It's very important that you identify that as your source of parliamentary authority. For those of you wondering, the latest edition of Robert's Rules of Order, newly revised, is the 12th edition. Every few years, they come out with a new edition and they always update and so on. So it's always good to just specify the latest version as opposed to for example, the 12th version, meaning that in a couple of years, you're going to have to update your board rules to account for the 13th edition of those rules coming out. So again, latest version of Robert's rules. Interpretation of the rules. Understand that the board chair serves as the ultimate authority on points of order or points of parliamentary inquiry. All right. However, Robert's rules recognizes that the board chair can consult the parliamentarian if there is one. Our board rules ought to designate an individual parliamentarian. I think it's appropriate that it be corporation counsel, because corporation counsel is in a position to evaluate the question before the board chair, not only in the context of parliamentary rules, Robert's Rules of Order, or your board rules, but also state law that may impact a particular question. And so I think it's really important that you designate your corporation counsel as the parliamentarian. There's nothing wrong with taking the time to get a decision right. I think it can be, oftentimes as a board chair, I think it can be intimidating to have a point of order or point of parliamentary inquiry directed at you where you were asked to rule on the spot whether a particular motion is in order or what a vote requirement may be or what something else means under the board rules. It's okay to say, okay, we're going to take a 5-minute break here, recess, so that I can consult with a parliamentarian and come back and provide you with my particular interpretation. Understand too that the board chair's interpretation is subject to appeal by the entire county board. So if the county board disagrees with what the board chair has ruled, somebody can make a motion, and if it's seconded, the body can vote as to whether they believe the board chair is correct. Because ultimately, it's the full county board that decides on those points of order or parliamentary inquiry, but it is up to the board chair to make that initial determination. Okay, and I think we've walk through everything. So before we get to questions, Jake, anything else that you wanted to address here?
No, I think, I think this has been a great 2 series of presentations, and, I think, you ended it well. Take the time to get it right, particularly with respect to Robert's rules. And then again, just generally speaking here, this is a great time to do a review. We can obviously help with that. WCA has lots of resources, but now's the time to review, to make sure that if there are unique issues to your county, that you can address them in board rules. I think Andy has done a great job kind of outlining the various options that you have, right? This isn't, I think we started 2 weeks ago on one of the first slides, encouraging people to certainly look to other board rules as a template, right? You don't have to reinvent the wheel on all this, but at the same time, make sure it fits your county, and to make sure that if there's something unique that consistently comes up from a board perspective, that you're addressing in the board rules so there's certainty.
Yeah, I think when we talk about the process of revising, updating your board rules, start that process now, go through a committee, go through corporation counsel. If we can be of assistance, we're happy to help. There are 2 counties right now that have engaged us to assist with revisions to their board rules. And I think this is a circumstance where the more eyes, the better, because we're going to miss something. Just given the breadth of the topic that we're discussing here and all the issues that we may confront that we need to address within our board rules, having a lot of people taking a look at them and considering what ought to be addressed would be appropriate. And again, we're happy to help to the extent that you need help. We have a question from Shabana here. For roll call votes, does the chair always get a vote? Yes, the chair is there as an elected supervisor representing constituents from his or her district. And so the chair always gets a vote. That would be my interpretation. Again, it's inconsistent with Robert's rules, who says the chair is supposed to act impartially and not vote unless there's a tie. But I think that the more important aspect of the chair's role is to represent the constituents he or she was elected to serve. Are they included in their designated spot in the rotating list, or should they be at the end as the tiebreaker? And I think I just answered that, Shabana, is that they should be in the designated spot, that we go through the process just like we would every other supervisor. So let's see if we have any other questions here. I think we have answered all of these questions. Oh, Kim asked a great question, and Kim's a corporation counsel and an experienced corporation counsel who has been in many more meetings than I have, and I'm sure dealt with this. She asked a great question. How are rules enforced, and by whom? That's a great question. Last week, we talked about this whole concept of designating officers of the county board and the ability to create a position like sergeant at arms. If you want to make sure that rules are enforced and we have one person responsible for enforcement, you can designate the sergeant at arms as that enforcer. Otherwise, it's up to the board chair to enforce those rules. We have the ability, of course, in the most extreme circumstance, to call in law enforcement if somebody is being disorderly in a meeting, but we never want to get into that position. What we'd much rather see is peer pressure to enforce compliance. And so if we have a strong board chair who is going to understand the rules, apply them evenly, and enforce those rules, there will be a natural inclination toward enforcement. And only in those extreme circumstances do we have to rely upon an outside source. Short of law enforcement, again, you can designate either the sergeant at arms, or you could even designate the second vice chair, for example, as the enforcer of those rules. It just depends upon what you need in your county and what you think is going to be most effective in enforcing those rules. And I think that's all the questions that we have here. I want to end this by saying thank you for your interest in these topics. Thank you for your interest in county government. None of this is easy. And so again, I'm going to say it. We've said it 10 times before. I'll say it again. If you need help, feel free to ask for help, because I think all of us can learn a little bit from each other as we go through these various circumstances. I also want to say happy holidays to everybody as we have the holiday occurring next week. So happy holidays, everybody. And I cannot wait to see everybody next year at these In the Boardroom sessions. So with that, Sarah, I'll turn it back to you so we can close out.
All right. Thank you, Andy. I was just going to thank everybody again for joining us for these this two-part series on county board rules. I think, as Andy knows, this happens to be one of my most favorite topics of discussion with him. But I want to thank you again for attending today, and a reminder that our next In the Boardroom, and our first one in 2024, is on January 24th at noon, where we will be discussing social media use by county board members, a topic that we've been receiving more and more questions about. So again, thank you so much for joining this recording, as well as the PowerPoint presentation will be posted on the WCA website later today. Otherwise, if there is nothing else, thanks again and happy holidays to everyone.